It's not
Put it out, your bill on legislative pay and benefits and all of that.
today we're planning on doing.
Senate will please come to order. Today's devotional exercises will be conducted by Reverend Walter Brownridge, the Episcopal Diocese of Vermont. Welcome.
Good afternoon. It's my pleasure to represent the Right Reverend Shannon McVeigh Brown, who is the 11th Bishop of the Episcopal Diocese of Vermont. I serve as her Chief of Staff, and to be here today for these deliberations. The prayer I have today is a poem that is attributed to the explorer and privateer Sir Francis Drake, which might seem to be controversial, particularly as in the 21st century, we understand things now that we may not have understood around the views of quote unquote discovery, colonialism, and so on. But those who know me know that it was my joy to work for several years under and with the Most Reverend Desmond Mpilo Tutu, Archbishop of Cape Town, South Africa. He taught me many things, including how to pray. And he was particularly fond of this prayer by this colonialist because, as he said, even cracked vessels can carry the living waters of God. Disturb us, Lord. Disturb us, Lord, when we are too well pleased with ourselves, when our dreams have come true because we have dreamed too little, when we have arrived safely because we sailed too close to the shore. Disturb us, Lord, when with the abundance of things we possess, we have lost our thirst for the waters of life. Having fallen in love with life, we have ceased to dream of eternity. And in our efforts to build a new earth, we have allowed our vision of the new heaven to dim. Disturb us, Lord, to dare more boldly, to venture on wider seas, where storms will show your mastery, where losing sight of land, we shall find the stars. We ask you to push back the horizons of our hopes and to push into the future in strength, courage, hope, and love. Amen.
Amen.
Thank you very much. Are there any announcements? Seeing none, I've got two announcements to make under Rule 31 referral affecting bills on notice calendar affecting the revenues or the expenditures of the state. The first one being S100. S100 affecting the revenues of the state will be referred to the Committee on Finance. And S32, affecting the expenditures of the state, will be referred to the Committee on Appropriations. We have some bills for introduction today. We have S131, introduced by Senator Chittenden. Please listen to the first reading of the bill by title.
S131, an act relating to high school student legal residency.
Now, you've heard the first reading of the bill is referred to the Committee on Education. And we have S132, introduced by Senator Ulick and others. Please listen to the first reading of the bill by title.
S132, an act relating to nominating petitions for a candidate for the office of a Unified Union School District Board member.
Now, you've heard the first reading of the bill is referred to the Committee on Education. One moment, please, if I could confer with... Thank you. We have S133, introduced by the Committee on Education. Please listen to the first reading of the bill.
S133, an act relating to miscellaneous changes to education law.
Now, you've heard the first reading of the bill, and being a committee bill, it will be placed on the calendar for notice. That brings us to the orders of the day. We have up for action today for third reading JRS 17, Before third reading, I'd like to ask if there are any amendments to be offered. Seeing none, please listen to the third reading of the resolution.
JRS 17, joint resolution urging U.S. Citizenship and Immigration Services to comply with the expedited asylum hearing provisions of the Afghan Supplemental Appropriations Act of 2022.
Now you've heard the third reading of the resolution. The question is, shall the Senate adopt the resolution? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you've adopted JRS 17. We now have up for action S94. S94 was read a first time and referred to the Committee on Finance. The Committee on Finance reports that the bill ought to pass. For the report of the Committee on, please listen to the second reading of the bill.
S94, an act relating to the City of Barre Tax Increment Financing District.
Now for the report from the Committee of Finance, Senator from Chittenden Southeast, Senator Chittenden.
Thank you, Mr. President. So this is a relatively very short bill, and I was happy to report on it because I have personal experience for 8 years on the South Burlington City Council working with TIFs. So if tax increment finance districts are new to any of you, I'm not going to go into the depth of that, but I would be happy to answer any questions between now and the third reading. This effectively does two things, and for reasons that I think are unique, are specific to Barre. The pandemic affected a lot of things, and just the timing of when they started their TIF was even less opportune for the delays, the extensions they already received. So this is effectively extending their TIF district in two parts, one more time, the final time, to allow for an additional 2 years for them to take on debt, and then also an additional 4 years at the end of the TIF increment cycle to redirect education fund revenues towards their projects. S94 would effectively extend the period that the City of Barre can incur indebtedness towards financing district until March 31st, 2026. It would also extend the period that they can retain the municipal and education property tax from 2035 to 2039, a period of 4 years. We didn't get a JFO note, but I got a JFO email on this, and the JFO email does predict that this 15 years from now, or 12 years from now, over a 4-year period, would have a cost to the education fund of an estimate between $1 and $1.3 million. But again, at the end of those cycles, as we all understand for the TIF, how TIFs work, the state will then be receiving the expanded, increased grand list revenues from the additional higher valued grand list. Your Senate Committee on Finance heard from Carolyn Dawes, City Clerk Treasurer, City of Barre, Karen Horn, Director of Public Policy and Advocacy for the Vermont League of Cities and Towns, as well as Nicholas Storlocastro, the City Manager of Barre. And your committee voted 6-1-0, and we urge this body to concur.
Now you've heard the report from the Committee on Finance. The question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of S94. It's my understanding we're going to pass over S6 for the time being, and that brings us to S37. S37 was read a first time and reported to the Committee on Health and Welfare, which reports that when amended, the bill ought to pass. Furthermore, the bill was then referred to the Committee on Appropriations, which also considered the bill and recommends when amended, the bill ought to pass. Please listen to the second reading of the bill.
S37, an act relating to access to legally protected healthcare activity and regulation of healthcare providers.
Now for the report of the Committee on Health and Welfare, the Senator from Chittenden Southeast, Senator Lyons.
Thank you, Mr. President. May I speak to the strike all amendment?
You may.
Thank you. You're receiving a one-page summary that's going around. This bill, and the bill is on page 220 of the March 15th calendar, and on today's calendar on page 246. So, Mr. President, Science and medicine has changed radically over the past 50 years, as we know. We've had improvements in how to treat folks with varying conditions related to reproductive services, including gender-affirming care, including other areas of reproductive care, which includes abortion. OBGYN folks, nurses, midwives, counselors, social workers have all become engaged in how to work with women who undergo care when they require and look for special care or for abortion services. We know that science has improved access to specific types of prescription and non-prescription drugs. We know that medicine now recognizes different types of problems, medical issues that come forward. And one of those in particular is the area of gender incongruence or gender dysphoria. And I'm going to talk a little bit about that first because it's important to understand what these things mean before we dive into the bill and before I introduce the bill specifically. But over time, we begin to understand that gender incongruence is a case where there's a disconnect in what one sees as one's sexual sex or assigned at birth as compared with how one identifies socially or with one's gender. Gender dysphoria is a discomfort or the distress caused by a discrepancy between a person's gender identity and their sexual expression assigned at birth. Gender dysphoria can be described as anxiety, it can be expressed as depression, self-harm. With adolescents, we see a reduction in school performance and social interaction. And this has become recognized as a symptomatic of a need to understand who one is sexually and who one is as gender identity. Because we recognize gender dysphoria and gender incongruence, then the medical community and the counseling community now knows how to deal with and treat through gender-affirming counseling and gender-affirming treatment to help adolescents and adults through support, through therapy, and to manage their dysphoria, and perhaps offer transition, gender transition. The treatment for gender dysphoria and gender incongruence is not a short-term process. It's a long-term process. And as we start talking about this, I think we need to understand that this isn't something you go in to your physician one day and be treated. Rather, it's a process of understanding who you are, working with families, working with parents, in the case of adolescents, in the case of adults, to have an ongoing relationship. So there are stages to the treatment for gender-affirming care that we learned about in our committee and that are so critically important to bringing people back into a social environment where they feel comfortable. Now, Mr. President, this bill is about the transition that we've seen in medicine over time and the recognition of the need for treatment. And we know that as part of that, of course, we'll be talking about reproductive care and abortion. For nearly 50 years, our state and other states have lived under Roe versus Wade. And it's allowed for Vermont and other states for healthcare professionals to provide reproductive care for both men and women and give access to counseling and support and decision-making around reproductive health care that includes family planning, contraception, sterilization, pregnancy, or termination of pregnancy. The Dobbs decision last summer upended our national understanding about reproductive autonomy. When the Supreme Court overturned Roe, the court sent decision-making about reproductive health to the states. And many states anticipated the Dobbs decision. Laws were immediately in place that banned abortion services outright or as early as 6 weeks within pregnancy. Other states have passed laws that restrict access to reproductive health care, including the care that we talked about earlier for gender dysphoria or gender incongruence. The result has been, you know what, before I go on, I'd like to read a short quote, if I may, from one of our folks who testified in committee.
Without objection, you may.
Thank you, Mr. President. This is from Dr. Erica Gibson at the University of Vermont, who happens to be the Division Chief of Adolescent Medicine at the Children's Hospital. What she has indicated is that since April 2021, we know about Roe, we know it was overturned, and we know that what we have gone through in this state in terms of our Article 22. But she indicates that since April of 2021, states have been aggressively after and combating and passing laws that are attempting to pass, and I'll read her quote. Other state legislatures have passed or attempt to pass discriminatory laws that aim to prevent young people and families from accessing appropriate gender care, and also seek to penalize gender health care providers for providing this care. To quote a pediatric colleague of mine, this is Dr. Gibson, who testified against one of these bills in Ohio, these bills are an extreme rejection of safe and effective medical treatment for a vulnerable group of youth. Mr. President, this bill is our opportunity to protect that group of youth, but it's also an opportunity to protect our healthcare providers. The result of the laws that have been passed as a result of Roe being overturned, and then the more recent laws looking at gender discrimination, the result has been absolutely turbulent and sometimes terrifying. It's an upheaval of our social fabric across our country. Every day, we read about another court case that chastises an OBGYN physician in one state for treating a 10-year-old in another state, a rape victim, or we read about the unfathomable Texas laws that allow any citizen to begin an investigation into any woman who seeks abortion services. Or we read about laws that prevent families from seeking gender-affirming care when a child has gender dysphoria. We read about efforts to eliminate emergency contraception. And I think today is a decision-making day around emergency contraception at the federal level. Today, we're not talking about legislative alternatives to Roe versus Wade. Vermont is fortunate to have our constitutional protection in Article 22 that provides reproductive autonomy in our state. And while the Vermont Constitution provides reassurances that we felt under Roe, our attention is drawn to the activities in other states. So that doctor from New York who provides the care for the child in Ohio can be protected against medical malpractice. That woman did not have a shield. This legislation will provide, and that I'll present today, is a shield for medical practitioners. It's a shield for insurers. It's a shield for Vermont patients. The legislation, when signed into law, will provide continued access to abortion services, provide practitioners protection for legally protected healthcare activity that includes gender-affirming care, ensure that fair and balanced information is available for those seeking abortion services, and help maintain access to emergency contraception. The legislation will ensure that gender dysphoria and gender-affirming care continue to be valued medical practice in Vermont. The bill is about medical care, legally protected health care, and professional standard of care, medical standard of care. And by the way, there is a bill in the Judiciary Committee, H-89, that is the companion bill to this bill, that will be worked on by, hopefully be worked on by our Judiciary Committee. So the definitions that we have in this bill will be the same definitions that we see when we look at H-89. And so there's been a lot of cooperation going on between and among the Ledge Council folks. For the most part, the legislation is modeled after a Massachusetts law that has been in effect in that state. So I'll go through the bill section by section. You have a one-page handout. And some of the bill is difficult to read, so I'm going to summarize what's in the bill. The page numbers that I give you are actually from March 15th. I haven't gone through today's calendar to give you that, but you do have the single page that will help with the sections. So page 221, and page 220, 221. So the first part of the bill is really about definitions and what we define as legally protected health care. The first set of definitions relate to gender-affirming health care services and reproductive health care services. So it's all the supplies and care and services relating to the treatment of gender dysphoria and gender incongruence. And then reproductive health care services are all supplies, care, and services relating to pregnancy, contraception, assisted reproduction, pregnancy loss management, or termination of a pregnancy. And then those two are included within the legally protected healthcare activity. The term legally protected healthcare activity is then utilized, and we'll see it throughout the bill. And it does include all of the things that I indicated before: gender-affirming healthcare, reproductive healthcare services. So legally protected healthcare activity includes the exercise and enjoyment of the rights to reproductive healthcare services and gender-affirming healthcare services. It indicates under our legally protected healthcare activity that assisting someone in exercising those rights, including the provision of healthcare services by a person licensed under the laws of the state and legally present in the state, so long as the service is permitted under the laws of this state. So what this means is that particular part of the definition of legally protected health care. That means that a physician in the state of Vermont can provide this legally protected health care. Could be counseling, it could be, if it's by telehealth, could provide that service to someone outside of the state and still be providing that service legally. The provision or issuance of insurance, and so this is a continuation of the definition. It also includes the provision of or issuance or use of insurance for reproductive health care and gender-affirming health care services. So it's okay to insure someone. It is required to insure someone in this state, as we'll see, to provide legally protected health care activity. What is not part of legally protected health care activity are there are no protections for an activity that might be construed as malpractice or illegal under the professional practice or liability in this state. Section 2 of the bill on page 222 is a section regarding medical malpractice. Essentially what this section does is it prohibits a medical malpractice insurer from adjusting or otherwise calculating a healthcare provider's risk calculation or premium charges for insurance due to the fact that the healthcare provider is providing legally protected healthcare, and that's the definition that we looked at in section 1. And so the provider can also provide or assist the provision of legally protected healthcare activity that is unlawful in another state, as long as it's legal in this state, that provider cannot have his or her insurance premium, liability insurance premiums increase because they are practicing standard of care that is in this state. There is a definition. There's also a section around how the malpractice applies, about the practitioner can't be held liable for another state's malpractice or activity. If it's not appropriate in the other state, you can't reach into this state and say you cannot provide that care. In Section 3, we see a section around health care, insurance, and gender-affirming health care services. Section 3 requires commercial health insurance and Medicaid to provide coverage for gender-affirming health care services. Simply provide coverage for it. Doesn't say how, or it doesn't say how much. It will require cost sharing, any cost sharing, co-pays, deductibles, or co-insurance for gender-affirming health care services can be no greater than cost sharing for the diagnosis and treatment of any other physical or mental condition under the health plan. So it's not going to be treated exceptionally. The health insurance, Section 4 is similar. It relates to abortion and abortion-related services under health insurance, requiring commercial health insurance and Medicaid to provide coverage for abortion and abortion-related services. And I'll just say, and then as part of that, again, for abortion, that requires that the coverage not be subject to any cost-sharing, co-pays, deductibles, co-insurance, except in the case of high deductible plans, and I'm happy to talk about that if you would like. But the point is here that what we heard from our Medicaid services is they already have fairly robust coverage for abortion. We heard that the costs, and so their co-pays will continue as they are now. They're very low co-pays. And then our commercial insurers were fine with having no co-pays or cost sharing for medical abortion, simply because it's a very low number of folks who are involved. And then well, there are many more details to this, but I think that probably suffices at this point. We heard support from the health insurers for both Section 3 and Section 4. There is a Section 5, which is really standard language indicating that should it be needed, that our Medicaid program can apply to the federal government for any waiver necessary to continue the coverage that they currently offer. Section 6 is a section from the Office of Professional Regulation, and it indicates that any board attached to the office, so in the OPR, we have boards of nursing, boards of pharmacy, boards, and then osteopathic physicians and others who may be engaged in offering legally protected health care activity. And so this prohibits the Office of Professional Regulation or a board attached to the office from taking disciplinary action against a healthcare provider or applicant only because they were providing legally protected health care or on the basis of some other state taking action against the provider. Section 7 is a similar section related to the Board of Medical Practice, where we see physician assistants and MDs, allopathic physicians. The Board of Medical Practice cannot take disciplinary action against a healthcare provider, including any adverse action against an applicant solely because they've provided legally supported healthcare activity, or on the basis of any criminal or other civil action in another state where the other state has a different set of professional regulations. Section 8 really begins what was a kind of an interesting place for us during committee to look at what are known as limited service pregnancy centers or crisis pregnancy centers. These are centers that are fully funded and provide free services for women who are seeking care, pregnancy care. They do not provide abortion services. They do provide counseling. There is a service exchange from one to the other. And so this really sets a standard for those centers. It's difficult because they may have a medical director and they have someone who does ultrasound for pregnant women so they can view the fetus, if there's a fetus, if they are pregnant, but they don't really offer abortion services. And we had heard testimony from individuals and from a bunch, not a lot, because this is a difficult area, let's face it. People don't just come in and say, I was seeking an abortion. That's not something that we do on an everyday basis. But we heard from folks who had sought care when they were younger, college students, and they went to one of these limited pregnancy centers and limited service pregnancy centers, and the time it took to find out that there was an abortion, the place for them to seek an abortion, it could have delayed them so that they might have had to continue the pregnancy. So one of the things we heard was that there's deceptive information that's given out at some of these places, that there's unfair information given out at some of these places, and certainly not all of them. We heard from some in Vermont who sound like they're trying to do a very good job at what they do, but there are some that are suspect. So this section, Section 8, establishes a new unfair and deceptive act in Title IX. That's the consumer protection part of the statute related to limited services pregnancy centers. And so there's a definition there. It's a pregnancy services center that does not directly provide or provide referrals to clients for abortion or emergency contraception. So both of those. And so it's quite a long section. You'll see it, that it declares that it's unfair and a deceptive act in practice in commerce for any limited services pregnancy center to disseminate to the public any advertising about the services or proposed services performed in that center that's untrue or clearly designed to mislead the public about the nature of the services provided. Alleged violations may be investigated by the Office of the Attorney General as a consumer protection violation. So, and under that consumer protection, there's misrepresentation or there's unfair and so on. It charges the medical director. So some of we did learn that some of these limited services pregnancy centers do have medical directors, and it charges the director, medical director, or the individual charged with supervising healthcare services provided by the center or volunteers with legal and professional responsibility for the activities of the staff. That gives them some liability, and failure to conduct healthcare services or to ensure healthcare services are conducted in accordance with the state law and professional standards of practice may constitute unprofessional conduct and result in a professional disciplinary action. So in other words, the medical director at these limited pregnancy centers are held accountable for under our professional standards of care. Section 9 is access to reproductive health and gender-affirming health care services. requires that the agency of human services include access to reproductive health care and gender-affirming care services as indicators of well-being. And there's a little community profiles of health and well-being that's on the Department of Health webpage, and you can go look at it. It has a significant number of very important aspects of what we have in this state for health and wellness. This section also requires the Green Mountain Care Board to include reproductive health care service and gender-affirming health care service needs in the healthcare resource allocation plan. As some of you may remember, the HRAP looks at what we have across the state for different types of services, and we've added into this our gender-affirming care and reproductive health care services, just to look at the availability of those services across the state from the Green Mountain Care Board. Section 10 and 10A relate to what we know as interstate compacts, and we've seen those here on the floor of the Senate previously around interstate compacts for nurses, interstate compacts for physicians, and we're going to see a bunch of them coming up, I understand, very soon. But within a compact, you can have some type of license to participate in healthcare activity in other states. So the states join together and they make rules about participation in other states and in the compact, and then you can practice in these places. But one of the concerns that our committee had was about our standard of care in this state and our legally protected healthcare activity might be in conflict with standard of care in other states. So we talked with the directors they're out in Colorado for our medical compact, and it's interesting the response we got, because they were not they weren't as excited about extending our standard of care to other states as we might have been. So we've asked our Office of Professional Regulation, our nurses, and our Board of Medical Practice, our physicians, to send us a report with findings and recommendations for any legislative action to address any concerns regarding the state's participation in interstate compacts. So there might be some things that we can put into the coming compacts that might obviate some of the problems that we would see with cross-border participation by our medical practitioners. And then we also in here have directed Vermont's representative. So each state has one representative. We have one in our state who goes and works with the interstate compact to develop rules of activity and participation. So we've directed them to seek amendments or exceptions to compact language or rules so that Vermont is not required to discipline a healthcare provider for providing reproductive or gender-affirming healthcare services that would have been legal provided in the state of Vermont. So we'll get those reports back. Section 11 is with regard to emergency contraception. Mr. President, I'm going on. We're not quite at the end, but all of these things are absolutely critical going forward to reduce the tensions that we feel in this state when we open the newspaper. Well, I guess we don't open the newspaper, but we go online every morning. So if we look at the section 11, emergency contraception in clinical pharmacy. So this section authorizes pharmacists to prescribe over-the-counter and prescription emergency contraception in a manner that's consistent with state protocols approved by the Commissioner of Health. Right now, we allow for pharmacists to provide albuterol and glucagon and SARS-CoV testing over the counter as needed when there's it's seen as an important emergency for patients. And this will add emergency contraception to that list. The other piece of this is to allow for over-the-counter emergency contraception, and non-prescription contraceptive drugs and devices available in vending machines. And so that you may have heard of Plan B, which is a specific over-the-counter emergency contraception. That would be one of the things that could possibly go into, it's a drug, a little hormonal thing, that could go into the vending machine. And it allows the Board of Pharmacy to develop and adopt rules to regulate the location and operation and utilization and oversight of vending machines. It's not something you do lightly, and certainly you want to have rules about the placement of these machines. So there will be a sort of an agreement that comes through the Office of from OPR and through our Department of Health. Sections 12 and 13 relate to access to reproductive and gender-affirming healthcare services. This really is about our public institutions of higher education. We know that the University of Vermont and our Vermont State Colleges have a significant young population, and we want to ensure that when young folks are experiencing gender dysphoria, that they can seek gender-affirming care, and if they have questions about contraception or abortion, that they can seek reproductive health care services. So this will ask the Vermont State Colleges and UVM to report to the Agency of Human Services with a readiness plan. What do they have in place currently for kids who are students who are seeking this type of support? And then we'll get a report from the Agency of Human Services about those readiness plans. It'll include things like the distance, or how close and proximal are they to a clinic where counseling might be available, or how close to a hospital, should they need the hospital setting. And obviously the University of Vermont is in a much better position than some of our more rural colleges. So this is seen as an important step for rural colleges, our Linden State, our Johnson State, and Castleton. Castleton's pretty close to Rutland Hospital. My teammates on the committee will not let me get away with not saying that. But so it allows for the colleges to really look at what's available, what kinds of materials do they need, what kind of transportation services, if any, might they need, and then finally, will they be able to place vending machines somewhere where students might access them with EC, emergency contraception. So then Section 14 is another critical section. They're all critical, but this one is important in terms of prohibiting the disclosure of protected health information. So essentially saying, it's really tough because in other states, people are targeted based on the type of health care they're seeking today. Going after emergency contraception, it might be targeted in one state. Looking for abortion care, abortion services, they might be targeted in a state. And so this really protects patient information. It prohibits covered entities, and it says business associates. So what this means, covered entities are like hospitals and clinics and anyone who would have healthcare information. And then business associates are all the nurses and all the other people who might have access to that information in those clinics. But it keeps those folks from disclosing protected healthcare information related to legally protected healthcare activity for use in a civil or criminal action, a proceeding preliminary to a civil or criminal action, or a probate, legislative, or administrative proceeding, unless the disclosure meets certain criteria. And those criteria include things like the patient can authorize the release, or it's required by federal or Vermont law, or the Supreme Court rules, or the disclosure is ordered by a court of competent jurisdiction pursuant to those various laws or rules. or it can be used to defend the covered entity or business associate against a claim. Or it could be a disclosure to Vermont's Board of Medical Practice or Office of Professional Regulation in connection with a bona fide investigation in Vermont. This section of the bill, as I indicated earlier, most of the bill is modeled after Massachusetts. This section is modeled more after Connecticut law and with some help from our own Judge Zone. So, Mr. President, I've gone pretty briefly, I think it's briefly, you probably don't, through the bill. And I will share with you that we took significant testimony. We worked hard to get the language exactly right. Our Ledge Counsel was so helpful in making sure that we aren't twisting our words up. Some of the language in the bill is difficult enough, so it was good that we could put it out in a way that is, we hope, understandable. But our witness list is long. I'm going to sort of summarize who we heard from. Our two Ledge Counsel folks, we heard from the Attorney General's office, we heard from the Office of Professional Regulation, the Vermont Medical Society, we heard from local providers, from Porter Medical Center, from the Medical Center of Vermont, from West Windsor, from UVM Medical Center, from the Vermont Board of Medical Practice, from the Green Mountain Care Board, from the Department of Vermont Health Access, from the Department of Health, from the state colleges, UVM, as well as our NVU folks. We heard from the Executive Director and Clinical Ethicist from the Vermont Ethics Network. We heard from Assistant Professor of Gender, Sexuality, and Feminist Studies at Middlebury. We heard from Planned Parenthood. We heard from the GLBTQ legal advocates and defenders. We heard from the Interstate Medical License Compact folks. We heard from our liability insurance providers, from our health insurance providers, student. We heard from Vermont Right to Life. We heard from our limited services pregnancy centers, and a new organization called Vermont Family Alliance. And so, Mr. President, that is the report. I will end there. It is a complex bill. It goes through many different titles because it covers a lot of different things. Overall, it offers protection for our healthcare providers who deliver a standard of care that we are used to in this state and that we would like to continue without assault from across our borders. So thank you, Mr. President.
Now you've heard the report of the Committee on Health and Welfare. Now for the report of the Committee on Appropriations is also the Senator from Chittenden. Sorry about that, to make you continue to stand.
Mr. President, thank you. We reviewed the bill and felt that any appropriations effect was very minimal and voted the bill out 6-1-0. And Senate Health and Welfare voted the bill out 4-1-0.
Thank you, Senator. The question now is, shall the Senate adopt the report of the Committee on Health and Welfare? Are you ready for the question? Senator from Franklin.
Thank you, Mr. President. May I interrogate the report of the bill?
The report of the bill is interrogated.
I've read a number of news reports that have simply raised the question regarding treatment of juveniles for gender dysphoria and similar kinds of conditions. How does this bill deal with, or does it deal with that? In other words, who decides if someone is too young for this kind of treatment? Is that left to a medical board? Is it left to a medical association? How is that done, if at all?
Thank you, Mr. President. That's a very good question. And of course, I will take a step back historically that we've had children born with sexual ambiguity for many, many years. And so what we've seen is that sometimes a child will be born, it looks like it may be a male, and so the child will be raised as a male. Similarly, we might see someone that looks like a female. And frequently, there may be surgical things that happen right then. That's happened in the past. Today, there are standard medical data-informed practices that are used to determine when, if, and how gender-affirming care is put into place. It is determined by, just like any of our other health care provisions, is determined through professional medical practice. And so there are, as I read the letter from one of our very outstanding medical practitioners in this state, that those clinical determinations are data-informed. And so to answer your question about how young, it's when the child might begin to demonstrate some gender dysphoria, some anxiety, some depression, some other issues related to being incongruent with what they were determined to be at birth with what they feel they are in a social environment. So there's no prescribed age. I will say that there are treatment protocols that are very, very much, I'll say they're prescribed, but they are within the medical profession. It's not like any other health condition. It's like any other health condition.
Does that mean that these medical practices are codified and are consistent across various medical associations?
You know, that is also a good question because there's so much frustration right now across the country with practitioners. Let's take, for example, OBGYN or an adolescent medicine, pediatric medicine. There's a lot of frustration in other states where folks have been trained to treat gender dysphoria, and yet they are prohibited from doing so. So it is a part of the medical practice itself.
Is there any requirement for parental involvement in the case of a very young juvenile presented with this condition?
Well, that's also a good question, and I know it's a question that was raised in our committee from the Vermont Family Alliance consistently. You have to have parents involved. But the way if it's an adolescent or a young child who's being treated, the family is engaged. You just can't do this without the family. And this is one of the things that we're seeing in states that are passing laws that are prohibiting gender-affirming care. We're seeing it's not the kid. The kid in some ways is not powerful enough to speak for him or herself. And it's the family, it's the parents who bring the issue to the attention of the practitioner. So the family is very much involved, the parent, the guardian, whoever is the responsible adult.
Well, does that mean that is a general practice for a family to be involved in a case of gender dysphoria as indicated by the child, but could the child in any circumstance approach a provider and have services provided without parental involvement? Is that possible?
Oh, we did not hear that in testimony, Mr. President.
But is it possible?
You know, I suppose what would happen, and this I think would probably be validated, is that the child could approach a practitioner, a counselor, someone for help. But if it's a medical practitioner, the practice is to work with the family.
Is there any prohibition that would affect a practitioner who did not?
That might be considered to be unethical and deviant from medical practice.
Suppose it was simply a psychologist or counselor who was counseling about gender dysphoria. There was no surgical or other kind of deep medical intervention involved? Is there any requirement that families or parents be involved in anything like that?
Well, as I said before, this is the part of practice, whether it's counseling or whether it's medical, whether it's a medical counselor or MSW or whomever it is, the practice in this area is to reach out to families.
Thank you, Mr. President.
Question is, shall the Senate adopt the report of the Committee on Health and Welfare? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have amended the bill as offered by the Committee on Health and Welfare. Question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. Nay. The ayes appear to have it. The ayes do have it, and you've ordered third reading of S37. We now have up for consideration S48. S48 was read the first time and was originally referred to the Committee on Economic Development. The bill was then referred to the Committee on Transportation. The Committee on Transportation recommends that when amended, the bill ought to pass. Please listen to the second reading of the bill.
S48, an act relating to regulating the sale of catalytic converters.
Now you've heard the second reading of the bill. For the report of the Committee on Transportation, the Senator from Chittenden Southeast, Senator Chittenden.
I know it's been a long afternoon, so I hope to keep these remarks brief. I also wanted to bring a prop in today, a catalytic converter. I was advised that's not allowed. But I hope that you all, as I talk about this, have in your mind something like a muffler that's attached to a lot of our vehicles. Since 2019, catalytic converter theft has risen 1,215%, according to the National Insurance Crime Bureau. According to the largest auto insurer in the U.S., claims for stolen catalytic converters doubled in the year ending June 2022, with a total of 43,200 stolen converter claims that year. Here in Vermont and in this State House, every time this bill has come up in conversation, somebody has either volunteered that their catalytic converter was stolen or that they have a loved one that had it happen to them. These devices attached to our mufflers are being hacked off of cars sitting in parking lots to be sold for scrap metal. Based on testimony, hacked off catalytic converters can be redeemed at metal scrap yards for amounts ranging from $200 to $900, depending on the composition of the materials used. But it costs thousands of dollars to have one of these installed, a new one installed. And once a catalytic converter has been hacked off, it can't economically be reattached. This is a growing problem that this bill attempts to address in two ways. First, this bill makes it just a little bit harder for a person, with the exception of motor vehicle recyclers and motor vehicle repair shops, to sell one or more detached used catalytic converters to a scrap metal processor. This bill also changes our current law from requesting available documentation from the seller to now requiring third-party documentation to be collected at time of sale that establishes the seller lawfully owns the items to be sold. This is how the bill started, and that alone will make it a little bit harder for stolen catalytic converters to be sold in the aftermarket here in Vermont. But the biggest criticism of this bill, as introduced, was that it did not go far enough to address the problem. To explore this issue further, your Committee on Transportation reached out to the New England State Police Information Network for additional perspective. From testimony by Nespin, Executive Director and his affiliates, we heard that what neighboring states have recently done addressing this growing problem. Just last year, Maine and Massachusetts passed new laws on catalytic converter thefts, going much further than this bill does, with required engravings, point-of-sale systems, and mandatory centralized tracking of all catalytic converter sales. That testimony inspired our committee, your committee, to add a tool to this bill inspired on what we hear Connecticut is now considering and what part of what Maine did last year. Our amendment to this bill adds a requirement that any person, again excluding motor vehicles, recyclers, and motor vehicle repair shops, any person transporting more than one detached used catalytic converter must have those catalytic converters permanently marked with the VIN of the vehicle that was last attached to, and that the person transporting the person just transporting it must have in their possession proof of lawful ownership of those devices. This is structured just as a legal requirement with a civil penalty rather than a criminal offense. The intent of this additional language is to give law enforcement the tool if they pull somebody over with detached used catalytic converters in the back of their truck or car, similar to what neighboring states have done. This bill isn't going to stop the theft of catalytic converters, but it is a step in the right direction, and with our neighbors, is helping to advance conversations at the federal level for new car sales and parts sales to serialize catalytic converters and make it even harder to sell stolen devices in the aftermarket. I have more information about what other states are doing, but I'll not offer that now. Your Senate Committee on Transportation heard from Carolyn Graham, Criminal Intelligence Services Manager, New England State from NESPN, Brian Grassi, Deputy Director of NESPN, David Hall, Legislative Counsel, William Irving, Vermont, New Hampshire Law Enforcement Coordinator, Curtis McKenzie, Executive Director, Casey Richards, Criminal Intelligence Specialist, Christopher Sorrell, CT Law Enforcement, Connecticut Law Enforcement Coordinator, Matthew Stewart, Maine Law Enforcement Coordinator, and David Will Wildgrub, Central Mass Rhode Island Law Enforcement Coordinator. Your Committee on Transportation voted 5-0-0 on this bill, and we encourage this chamber to concur.
Take a breath.
Yeah.
You've heard the report of the Committee on Transportation. The question now is, shall the bill be amended as offered by the Committee on Transportation? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have amended the bill as offered by the Committee on Transportation. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have ordered third reading of S48. That completes the orders of the day. I'd now like to recognize the Senator from Chittenden Central.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until Friday, March 17th at 11:30 a.m.
Now, the Senator from Chittenden Central has moved pending announcement that the Senate stand adjournment until Friday, March 17th at 11:30 a.m. Are there any announcements? Senator from Addison.
Thank you, Mr. President. The Senate Government Operations Committee will meet 10 minutes after the floor, but please be on time, everyone. Thank you.
Senator from Bennington.
Thank you, Mr. President. Senate Education will meet 15 minutes after the floor.
Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 2:15.
Senator from Essex.
Thank you, Mr. President. Senate institutions will meet, and immediately after follow the gavel, we have witnesses waiting.
Senator from Chittenden Southeast, excuse me.
Really try not to talk this much, but one of the legislative pages is celebrating a birthday today, and that page happens to be my daughter. So I felt obligated to just stand up, and if you see little Amelia, please wish her happy birthday. Thank you, Mr. President.
Senator from Bennington, Senator Sears.
Thank you, Mr. President. Senate Judiciary will meet at 8:45 tomorrow morning, 8:45. Thank you.
Are there any, Senator from Addison?
Senate Natural Resources and Energy will meet tomorrow morning at 8:30. Thank you.
Do I hear 8:15? Anybody? 8:15. Are there any other announcements? Seeing none, the Senator from Chittenden Central has moved that the Senate now stand adjournment until Friday, March 17th at 11:30 a.m. Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and the Senate will stand adjournment until Friday, March 17th at 11:30 a.m.